Hey, folks, welcome. Let's see if I can get anything working right today. Sorry about the slightly messed up intro, but welcome to today's episode. Whoops. Good heavens. Let's start again. Welcome to today's episode of the Law of Self-Defense Show, where we will be looking at the statement of probable cause charging Alec Baldwin with involuntary manslaughter in the shooting death of Halyna Hutchins. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Wow. Super loud. Thank you so much. Sorry for the slight delay when we throw these shows together at the last minute, as I have here. Then sometimes this kind of stuff happens. So come on in, folks. Make yourselves comfortable. Let me make sure everything is streaming the way it should be. It appears that it is. Let's see. Refresh Twitter. And it is complete with all the editorial glitches. So that is good to know. As we go through this, folks, as always, if there are any questions, there are two ways to ask questions. The best way is to be a Law of Self-Defense member and watch this, participate with this on the Law of Self-Defense membership dashboard. I see a bunch of members filtering in. There you can post as many questions as you like for free. It's part of being a member. We don't charge you for questions. I do ask that you preface your question with the word question in all capital letters, so it's easy for me to pick out from the chatter. Alternatively, you can ask your questions on YouTube if you're watching this live on YouTube, but in that case, they need to be in super chat form. $5 minimum super chat on YouTube to get questions answered. Frankly, it's crazy, folks, not to just be a Law of Self-Defense member. You get as many questions as you want answered every month for less than $10 a month, about 30 cents a day, as opposed to paying $5 per question, a third of which, or 40% of which, whatever, goes to YouTube. And you can become a Law of Self-Defense member right now. You can do it right now by pointing your browser to lawofselfdefense.com/join. lawofselfdefense.com/join. 30 cents a day. Get as many questions as you want answered by me personally, or pay $5 super chats. So that's how the questions work. So what are we looking at today? Today we are looking at the statement of probable cause that has been handed down in New Mexico against Alexander Ray Baldwin III. We all know him, of course, simply as Alec Baldwin, the actor of the Baldwin family, only very distantly related to Adam Baldwin, a fine actor and good friend of mine. Many generations back, the Baldwins were apparently, Adam tells me, were related, but that was long ago. They're certainly not on particularly friendly terms. Today, as you may know from the Adam Baldwin interview I did some weeks ago. By the way, I've written about this case extensively since the day after it happened, and you can find all my analysis and commentary on this shooting, many blog posts, videos, podcasts, all aggregated at lawofselfdefense.com/Baldwin. And because this is a case of widespread public interest, we've left those blog posts unlocked. So you don't need to be a member to see those. And this one will join that aggregated collection of Baldwin stories when we're done with it today. So a quick overview. On October 21st, 2021, Alec Baldwin was the actor on the set of a low-budget Western being filmed called Rust. Halyna Hutchins was a cinematographer. They had basically a rehearsal camera setup scene in which Alec was drawing a single-action Western-type revolver from a holster, pointing it towards the camera at Halyna Hutchins' direction, and the gun discharged. While it was pointed directly at Halyna Hutchins, it killed her, mortally wounded her. The bullet then penetrated through her and hit Joel Souza, who was, I believe, assistant director or director on the set. And questions immediately arose. This happened October 21st. I first wrote about this event on October 22nd because the news, the general media, was reporting this as a terrible accident that had happened on a movie set. And my view was, my initial view was, well, maybe it was an accident. It's possible. But it's hard to have an accident when you're handling a firearm because the standard of care for handling a firearm, handling any inherently dangerous instrument, is very high. And almost invariably, if you're handling an inherently dangerous instrument like a gun or explosives or dangerous chemicals, there are stringent safety measures that are in place. And if you, to prevent someone from being unintentionally killed by those inherently dangerous instruments, and if you violate those safety measures and end up killing someone, that's not an accident. That's recklessness, criminal recklessness, and the death becomes involuntary manslaughter. So I said, here we have a death by gun. It's quite likely that this is not at all an accident in the legal sense. It's very likely it was an unintentional killing, and the colloquial use of the word accident would apply there. But in the legal sense, an accident is something quite different. It was very likely, I wrote the day after the event, that this was actually involuntary manslaughter. And 2 days later, I had a much more in-depth analysis, legal analysis of the shooting, where I looked at New Mexico statutes, New Mexico case law, and it became pretty clear that this was an open and shut case of involuntary manslaughter. And I had that analysis within days of the shooting. Now, 13, 14 months later, the district attorney in that judicial district of New Mexico has decided to agree with me, which is a little surprising because Alec Baldwin, of course, is well known as a Democrat. And she's well known as a Democrat. She's a democratically elected politician. This is a liberal part of New Mexico. New Mexico is pretty liberal anyway, but this is the Taos, Santa Fe area of New Mexico. Alec Baldwin's famously anti-gun. He's on the board of a gun control organization. This district attorney, not favorable to guns. So you think of them politically as being members of the same tribe. I would not have been surprised if Alec Baldwin had not been charged in this case for political reasons, despite the legal merits for the charge. But now he has been. And we're going to read through the statement of probable cause that the district attorney has released to justify her charging of Alec Baldwin. Now, just as an aside, this statement of probable cause essentially skirts the need for a grand jury. So there will be no grand jury here. Essentially what happens is the district attorney writes up the statement of probable cause, the factual basis and the legal basis why she believes she has probable cause that Alec Baldwin committed the charge of the crime of involuntary manslaughter. Then that will be presented to a judge, and the parties, the state versus Alec Baldwin's legal counsel, will argue the question of probable cause. 99.99999% of the time, the judge accepts the state's view of probable cause. We don't have a real probable cause standard in America. Basically, if the prosecution waves its hands, the courts deem probable cause to be present, which is unfair to anybody, even though they are Alec Baldwin. It's not the standard I would have. It wouldn't help him here if we had a real probable cause standard, because he's way past it on the facts and law in this case. But I see many, many cases in which there really isn't, by my standard, probable cause to drag someone to trial, and nevertheless, away they go. Here, a trial is more than justified in the law and facts. Now, I talked earlier about accident and recklessness, so it's useful, I think, to do a quick overview of these different mental states that can apply in this kind of legal analysis. And the two extremes are an intentional killing, which would simply be murder on the one end, and on the other end of the extreme is a genuine accident in the legal sense. Not just something that was unintended, but an accident in the legal sense for which there was zero legal liability. There's no civil liability. There's no criminal liability. And typically a genuine accident occurs when the unfortunate outcome was completely unforeseeable by the person involved. So imagine, I don't know, you work in a warehouse and someone asks you to carry a box from one end of the warehouse to the other. And the box is otherwise unlabeled. You have no idea what's in it. It's not particularly heavy. There's no reason to think it's dangerous in any exceptional way. And you're carrying the box across the warehouse, and for whatever reason, unforeseen reason, you trip or you stumble, somebody bumps into you, the box gets dropped. And unknown to you, there was a loaded gun in that box. And when the box crashes to the ground, the gun discharges, shoots, and kills somebody. That's a genuine accident from your perspective as the person carrying the box, because you had no idea there was a gun in there. You had no idea this unfortunate event was even a possibility. Genuine accident, zero legal liability. neither civil nor criminal. Next up, the ladder of mental states would be negligence. Negligence is where you didn't actually know there was a gun in the box. The box was not labeled gun. No one told you there was a gun, but you work in a warehouse that handles a lot of guns. Most of the boxes contain guns. And let's pretend for our hypothetical, the guns are generally loaded. Of course, they wouldn't be in real life, but let's pretend. So the box you're carrying isn't labeled gun. No one told you it has a gun, but you know from experience working in this facility that it's quite probable this box has a gun in it. In other words, you should know that there's a substantial risk there's a loaded gun in this box, and if you drop it, it could go off. Arguably, that's negligence. You didn't have an active awareness or knowledge that you were carrying a box with a loaded gun, but one could argue that you should have known that that risk was present. And then the unfortunate result happens. When you should have known a risk, but didn't actually know, but should have known the risk, and the unfortunate result happens, that's negligence. And negligence is the basis for civil liability, but not for criminal liability. So you might be sued and lose, but you wouldn't be an appropriate target for criminal prosecution. Next up the ladder of mental states, we have recklessness. Recklessness is kind of an aggravated form of negligence. With recklessness, you did know that there was a risk, an unjustified risk of harm to other people, and you ignored the risk and did the conduct anyway, and then you had the unfortunate result. And the classic example here is drunk driving. So we all know if you're driving drunk, you're creating an unjustified risk of death or serious bodily injury to other people. You don't have an intent to hurt other people. That's what distinguishes recklessness from intentional murder. You're not intending to hurt anybody. When you're driving home drunk from the bar, your goal is not to run people over. Your goal is simply to get home. But you know that getting behind the wheel drunk and operating that vehicle creates an unjustified risk of death or serious bodily injury to others. That's the recklessness. You knew it. You knew the risk was present. You ignored the risk, and then you managed to run somebody over while driving drunk. That's a form of reckless homicide. Not murder, because it's not an intentional killing, but it was recklessness because you were aware of the unjustified risk and you did it anyway. And then, of course, we have an intentional killing where you simply decide, even if the decision's made in an instant, but you're deliberately intending to kill that other person, we have murder. Now, recklessness takes a slightly different form from the drunk driving incident when we're talking about inherently dangerous instruments. These are instruments which, if not handled with due care and circumspection, special care, especially attentive care, create a substantial risk of death or serious bodily injury to other people. And this would include things like the handling of explosives, the handling of dangerous chemicals, the handling of dangerous drugs, operation of particularly heavy machinery like cranes and so forth, and the handling of firearms. Firearms are inherently dangerous instruments. And so the standard of care is very high. And all of these inherently dangerous instruments, they have value for society, right? Guns have positive externalities. They're useful to society. Cranes do, chemicals do, explosives do. So society wants to have the benefit of those positive externalities, but we want to mitigate as much as possible the negative consequences of handling these inherently dangerous instruments. So what we do is we build a bunch of safety rules about them. And then we treat them as if everybody knows that these are exceptionally dangerous things. You are presumed to know that you're handling an inherently dangerous instrument, that you have a legal duty to abide by the safety precautions around them. If you violate those safety precautions and someone dies as a result, it's simply treated as recklessness because of the nature of the inherently dangerous instrument. And with respect to guns, so you can't argue that it's not credible to argue you didn't know the dynamite was dangerous, right? It's not credible to argue you didn't know the arsenic was dangerous. It's not credible to argue that you didn't know the actual gun didn't have a real possibility of killing someone else, unless you're handling it in accordance with the required safety rules. And what are the required safety rules in the context of handling a gun? Well, there's only 4. Those four are: you treat every gun as if it's loaded, meaning parenthetically, well, okay, here comes the train. Sorry, folks. Choo-choo. I love this office. It'll go by in just a moment. That, by the way, for as liberal as Colorado is becoming, that is one of about 10 train loads of coal that travels through my town every day from the coal mines of, I believe it's South Dakota, all the way down to Pueblo, Colorado, where we have a giant electric generating station that runs on many train loads of coal every single day. And I'm happy to have the electricity. But the choo-choo I could do without. All right, so 4 rules of gun safety. First, you always presume every gun is loaded, at the very least, until you personally check to ensure it's not. Now, obviously, we have this checking provision because there are practicalities to handling a gun, right? At some point, you want to strip the gun, disassemble the gun for cleaning, for example. While you're disassembling it, you're not presuming it's loaded, because before you start disassembly, you personally check to make sure it's not loaded. None of us would field strip a loaded gun. We check to make sure it's not loaded. And once we verified that this gun in our hand is not loaded, then we can handle it in ways we wouldn't handle if we hadn't checked, like field stripping it for cleaning, right? The second rule is know your target, what's beyond your target. So know what you're shooting at. This mostly doesn't apply in the Alec Baldwin situation because it applies to intentional shootings. You intend to discharge the gun at a particular target. Well, you want to make sure that deer you're shooting at is actually a deer, not a human being. That's know your target. Know beyond your target is bullets overpenetrate. And you want to make sure you're not sending a bullet traveling a couple miles down the way where it could hurt someone, damage property. Bullets never miss, folks. They never miss. They keep going until they hit something. It just may not be your intended target. More relevant here are 2 remaining safety rules are: never point the muzzle at anything you're not willing to kill or destroy. Why is that? Because the muzzle is the point of the gun from which the bullet emerges. That determines where the bullet is going to strike. So muzzle direction, very important. That's where the bullet goes. And the last rule is don't press the trigger unless you want the gun to fire. So trigger, finger discipline. Modern firearms, and by modern, I mean last 150 years, they really don't discharge unless the gun is, unless the trigger is depressed, at least in the context of the type of revolver we're talking about here. Genuinely original series Western single action guns, in theory, if you drop them, you could drop them on the hammer could hit a cartridge in the cylinder and discharge the gun without the trigger being depressed. That's why cowboys back in the day would carry their revolvers with that particular cylinder empty. So if the gun were dropped, if the hammer were struck, there'd be no round below the hammer to discharge. More modern replicas of these kinds of guns have safety mechanisms in them that block the hammer unless the trigger has been pulled back to the rear. And Alec Baldwin's revolver had this kind of safety mechanism in it. So it couldn't, as the FBI would attest later, we'll get to that, Alec Baldwin's revolver, in fact, could not discharge without the trigger being pulled to the rear. So the nice thing about these 4 safety rules is there's a built-in redundancy, because for a bad thing to happen, in our context, let's call a bad thing being a person unintentionally shot, you have to break multiple of the safety rules, right? So if you imagine that the gun is not loaded, but it is, and somehow it goes off, well, as long as you had it pointed in a safe direction, you're probably okay. I mean, it's not good, but you probably didn't kill someone unless you had the gun pointed at somebody. And the other safety rule says you're not supposed to have the gun pointed at somebody that you're not willing to kill or cause serious bodily injury to. If you point the gun at someone you're not willing to kill or cause serious bodily injury to, but it's not loaded, in fact, not loaded, not just you imagine it's not loaded, but you checked, well, then you don't get the bad outcome, because a genuinely unloaded gun can't discharge a round. Even if the gun were loaded and pointed at someone, if you don't depress the trigger, again, modern firearms won't discharge. So for this Halyna Hutchins shooting to have occurred, And again, we're setting aside the know your target one because that applies to intentional discharge of the gun. And here we're presuming that Alec Baldwin's discharge was not intentional, conspiracy theories aside. Here, for Alec Baldwin to shoot Halyna Hutchins, he had to violate all the 3 remaining safety rules. The gun actually had to be loaded, which means he didn't check. He had to actually depress the trigger because the gun doesn't discharge unless the trigger is depressed. And he had to have the muzzle pointed directly at Halyna Hutchins, or the bullet would not have struck her. So he violated all 3 of the relevant gun safety rules here. And because guns are inherently dangerous instruments, and those safety rules define the standard of care for the handling of that particular form of inherently dangerous instrument, the gun, that's recklessness. And if you kill someone while engaged in reckless conduct, it's classic involuntary manslaughter. So that's where my analysis came down. Now, I will say, and we'll see it when we go through the statement of probable cause, that there are alternative paths to getting to involuntary manslaughter through Alec's responsibility as a corporate officer, as a director on the set of the movie. Those are different legal theories that he had a different type of responsibility for safety on the set. I've never explored those because, of course, my expertise is use of force law. I'm not saying they're illegitimate, just saying I have not previously discussed those. That wasn't my legal analysis. I think they do have merit, and I will cover them as we go through the statement of probable cause, but you don't need both. If Alex had simply been an actor, a hired hand on the set, and had no authority over anything, merely having pointed the gun at Halyna Hutchins, depressing the trigger, and not checking first to ensure the gun was not loaded, that all by itself is involuntary manslaughter when that shot kills her. All this corporate responsibility stuff doesn't matter, or I should say, is not required for a conclusion of involuntary manslaughter. It's kind of more reasons why Alec Baldwin should be held accountable, all this corporate accountability type of language, which is fine. I don't blame the district attorney for bringing it in. It's certainly part of the facts and the law in this unfortunate death. All right, so let's see. Before we jump into the actual probable cause statement, I should mention, of course, today's show is sponsored by none other than Law of Self-Defense ourselves. We have coming up on Saturday, April 15th, our Law of Self-Defense Advanced class. This is our full day class taught live by me on how you can be hard to convict, how you can be an unattractive target for prosecution if you're ever compelled to defend yourself, your family, or your property from criminal predation. This is the only Law of Self-Defense Advanced class scheduled for 2023. Saturday, April 15th, full day, 6-7 hours. All your questions are answered. It's a live show taught live by me, plenty of opportunity for Q&A. We cover everything imaginable about use of force law. It is applicable to all 50 states, so it doesn't matter what state you're in. And best of all, if you sign up this month, the month of February, for that April 15th class, you get 25% off the registration. Next time we teach this class might not be till 2024, folks. How long can you wait? When are you going to be attacked and be compelled to defend yourself? Are you sure it won't be till 2024? You don't get to choose, right? You don't get to decide the time, place, and manner in which you're attacked. The bad guy does that. Your obligation to yourself, your family, is to be prepared today for an attack that could come tomorrow. So don't delay. Sign up for this Saturday, April 15th class. 25% off if you sign up for that class this month, the month of February, at lawofselfdefense.com/advanced. Okay. So let me take a quick look and just check to see if there's any questions I already need to answer. I know I saw some come in from members, and I've discovered that the member chat only kind of holds on to the last 100 comments. So I do need to keep in mind to check it from time to time. And folks, I really got to limit my questions to the Alec Baldwin situation. I see there's questions here from the Alec Murda trial that's currently taking place that I am covering every day of the week as a guest on Ricardo Law. I'll be doing that again tomorrow. That's where to ask those questions. Ask them as super chats on Ricardo Law, and Nick and myself and whatever lawyers happen to be on the panel will be happy to address them. But in terms of efficiency and conciseness, I have to keep today's show to Alec Baldwin stuff. Okay, so let's see. Let me take a look. That was the members there were a couple questions, but that's what they were about. So sorry, folks. Let's see. And no super chat questions yet. All right, so let me pull up the statement of probable cause. And basically, I'll be reading through it and stopping occasionally for commentary and to answer questions as they come up. See if I can zoom that in. All right. You know what? I'll even do this. Here we go. Okay, State of New Mexico, County of Santa Fe, 1st Judicial District. State of New Mexico is the plaintiff. And Alexander Ray Baldwin III is the defendant. Kind of odd to use the plaintiff term there. That's usually for civil suits. But whatever. Statement of probable cause. So, background synopsis. This is just a recounting of the relevant facts in the case as the prosecutor believes to be relevant. All right. Background synopsis. On October 21st, 2021, in the County of Santa Fe, State of New Mexico, that's how we establish jurisdiction, a shooting involving a handgun/revolver, a firearm, occurred that resulted in the death of Halyna Hutchins and the serious injury of Joel Souza. By the way, Souza, of course, was not killed, so there wouldn't be a count of involuntary manslaughter for him because manslaughter is a killing crime. I'm somewhat surprised that given that they feel they have the factual and legal basis to charge Baldwin with involuntary manslaughter for the death of Hutchins, that they have not charged a second count of reckless endangerment for the serious injury to Joel Souza. I guess they didn't want to bother with that. I'm not sure, but basically the underlying legal rationale would be the same. To continue, the shooting involved a .45 caliber revolver and occurred on a Western movie set located in rural Santa Fe County, referred to and known as Bonanza Creek Ranch. On the state, being filmed and or rehearsed at this location was a film at the time referred to as Rust. Through interviews, statements, and evidence, it was learned that defendant Alec Baldwin, hereinafter Baldwin, was the lead actor in the film. Through these interviews and statements and physical evidence, it was also learned that Baldwin was involved in and named as a primary producer of the film. Through these same statements, interviews, and evidence, it was determined that after lunch on October 21st, 2021, the crew, production staff, camera crew, and actors were preparing for a scene set in the church. This was not an established rehearsal, nor had filming commenced. At this point, Baldwin was seated in what is referred to and appears to be a church on this movie set. Baldwin was in possession of a .45 long Colt caliber revolver type firearm, one of a type and kind often used and or seen in or on Western genre type movies and or sets. The firearm is a single action revolver handgun, which requires the cocking of the exposed hammer, which then rotates the cylinder, and then the pressing of the trigger is required to fire the weapon. So for folks who don't know, handguns routinely come in one of two forms. I'm not even going to get into the striker stuff, folks. Let's just deal with hammer-fired weapons, single action and double action. A double action revolver in this context means that the trigger does two actions, double action. As you depress the trigger, it mechanically cocks the hammer. That's the first action. And then as you continue to depress the trigger, it also releases the hammer to fire the round. So you can simply, with the hammer down, you can simply point that weapon, sweep through the trigger pull, and it cocks and releases the hammer. Double action, cock and release. Single action revolvers, the trigger cannot mechanically cock the hammer. If the hammer's down and you're pressing the trigger, nothing happens. You have to manually cock the hammer back. And then the single action of the trigger is to release the hammer. It's not cock and release, it's only release. That's relevant here because that means there were two deliberate actions taken by Baldwin here. Because first he had to deliberately cock the hammer, then he had to depress the trigger. And the more deliberate actions that are required in a process, the less likely it is to have been a genuine accident. Continuing, in front of Baldwin, standing, were victims Halyna Hutchins and Joel Souza. Hutchins and Souza were viewing and moving a camera for a possible setup for a later scene to occur at a later undetermined date and or time. Through these same statements, interviews, and physical evidence, it was learned that Halyna Hutchins was the director of photography for the film, and Joel Souza was the director/writer for the film. Information and evidence obtained show that Baldwin was seated in a pew facing in a northerly direction towards the front of the church. In front of him were Halyna Hutchins and Joel Souza and a camera operator, along with other crew, sound, script, costume, etc. By the way, all these people could have been the basis for charges of reckless endangerment. Continuing, Baldwin was wearing a shoulder holster, right-hand draw, which was holding the .45 long Colt caliber single action 6-shot revolver. Colt should be capitalized there. Proper noun. Baldwin was practicing drawing and pointing the weapon for the scene with guidance and instruction from Halyna Hutchins and Joel Souza. The setup was to be a close-up on Baldwin and the firearm as he drew the weapon and pointed it. Halyna Hutchins and Joel Souza were viewing the practice scene on a monitor attached to the camera. Baldwin drew the revolver from the holster, pointed it at Halyna Hutchins, and fired the weapon. When reviewing the script and witness interviews for this particular scene and close-up shot, evidence indicates the scene shot did not require the weapon to be fired. It was also determined by consultation with expert armorers that in a rehearsal, a plastic gun or replica gun should be used, as no firing of blanks is required. However, Baldwin fired the single-action .45 long Colt revolver, resulting in the discharge of a projectile that struck and traveled through the right armpit area of Halyna Hutchins, exited her back from, I guess, OMI must be the medical examiner's official report, then struck Joel Souza in the right shoulder and lodged into his right back. So I'll pause there, folks. Many people ask, why do they use real guns on movie sets? I mean, this couldn't happen if you didn't use real guns. Why not inert guns or guns that can only fire blanks or whatever? Now, I'm not saying this is a good reason, and I can't claim to have extensive experience with Hollywood. I have worked on TV productions. I've been on TV productions, so I've observed the set and how things operate. I've spoken to people extremely knowledgeable about handling guns on real movie sets, like my friend Adam Baldwin. But the bottom line reason that the sets use real guns is because the guns look real. And there may be close-ups, the way the light glints off the guns, the way they sound when they're cycled, for example, and they're cheap. They're cheap. Guns are inexpensive for the most part, and having a supply of very, very realistic-looking fake guns that would appear real, even on close-ups, like when the guys do this, could very well be really expensive and troublesome, and they just don't need to bother because we live in America and there's companies set up for Hollywood that are well equipped with a wide variety of real firearms. And if you follow the safety rules, it's really not a problem. I mean, keep in mind, these shootings on sets are extremely rare, even though many, many thousands of guns are handled on TV and movie sets in America every year. And what perhaps once a decade, once every 2 decades, 3 decades, something tragic like this happens. So the real guns are safe to handle on a set if they're handled in a responsible way, consistent with the rules for gun safety. Maybe the industry will move away from real guns on sets after this, but I don't think so, because I think they can just say, hey, this was a rare event that occurred because people involved didn't follow the rules of gun safety. I would expect the following of those rules to be tightened up, especially if Baldwin goes to prison. Continuing, at approximately 1:48 p.m., the shooting was reported to the Santa Fe County Regional Emergency Communications Center via 911. This resulted in the response of fire, emergency medical, and Santa Fe County Sheriff's Office personnel. This further resulted in a case number, CAD incident number, being generated. The Santa Fe County Sheriff's Office conducted an investigation into the shooting under this case number as a death investigation. Detective Alexandra Hancock was assigned as the primary investigator. The response of emergency personnel resulted in Joel Souza being transported by ambulance to St. Vincent Regional Medical Center, located, well, the address doesn't matter, in Santa Fe, New Mexico. Halyna Hutchins was transported from the scene by air ambulance helicopter to the Level 1 Trauma Center at the University of New Mexico Hospital in Albuquerque. Halyna Hutchins was pronounced deceased at approximately 3:37 p.m. by attending medical personnel. Joel Souza was treated and released, but not before a projectile was removed from his back. The projectile appeared to be a lead projectile of the type and kind found in live ammunition. It was a bullet, folks. It was just a .45 long Colt bullet. This item was secured and turned over to the Santa Fe County Sheriff's Department. As noted above and confirmed by the evidence and analysis, the recovered projectile first struck and then passed entirely through Halyna Hutchins and then struck Joel Souza. There was no evidence that the bullet ricocheted, struck any object or person before striking Halyna Hutchins. Now, this is relevant, folks, because it demonstrates that Alec Baldwin violated that safety rule of not pointing the muzzle at something you're not willing to kill or destroy. This was not a ricochet hit. He did not have the muzzle pointed in a safe direction, and the round discharged and took a weird bounce before it hit Halyna Hutchins. Absent a ricochet, striking some other intermediate object before hitting Halyna Hutchins, we know as fact that the muzzle necessarily had to be pointed directly at Halyna Hutchins. The projectile then penetrated through the front of Joel Souza's right shoulder, became lodged under the skin on his back. The Office of the Medical Examiner, State of New Mexico, listed Halyna Hutchins' cause of death preliminarily as gunshot wound of the chest after conducting an autopsy on October 22nd. So, let's see. The following additional information and evidence is provided in further support of probable cause of the enumerated crimes having been committed by Baldwin. All right, let me pause there. That's the bottom of the first page. See if more questions have come in. Law Self-Defense Member Dashboard. Just refresh the page there. And the super chats. Let's see. Okay. Statements and evidence show Baldwin was not present for required firearms training prior to the commencement of the film. There's quite a bit of this stuff in here, folks. In fact, Baldwin has had extensive firearms training throughout his very lengthy Hollywood career. He's handled real guns on many sets, many times. He's fired real guns. He knows they're dangerous. He's on the board of a gun control organization that exists on the premise that guns are dangerous. So he's well educated and informed on this stuff. I'm not sure. I mean, I have to be honest. I wouldn't need to participate in a firearms training course before I handled a real gun on a set. I have extensive experience handling real firearms, even under crowded circumstances. So I'm not sure it really matters that he skipped this particular training, but it doesn't look good, does it? I mean, even with all my experience, if I were on a movie set and they said, listen, everyone handling a gun has to undergo this training, I say, sure, great, let's do it. It won't be anything I haven't heard before, but never hurts to refresh your recollection. And if that's the rule, I want to follow the rule, right? Statements, depositions from OSHA, and evidence show Baldwin was provided only minimum firearms training on firearms. Even after Reed, this was one of the directors or assistant directors, requested more training for Baldwin. In the deposition taken from Reed, she stated Baldwin had very limited training on the cross draw that was required for the scene on the 21st, and limited training in firearms and how to check his own firearm as to whether it was unloaded or loaded, in which Reed felt it was very important in his role as Rust, I don't know, director. A training session for at least an hour or more in length was scheduled, but the actual training consisted of only approximately 30 minutes, as according to, Reed is Gutierrez Reed, Hannah Gutierrez Reed. That was the armorer on the set. My apologies. A training session for at least an hour or more in length was scheduled, but the actual training consisted of only approximately 30 minutes, as according to Reed, Baldwin was distracted and talking on a cell phone to his family during training. Also doesn't look good. Baldwin approached responding deputies on the day of the shooting, wanting to talk to them because he was the one who, quote unquote, fired the gun. He was referred to and later interviewed by detectives. Baldwin later asserted that he never fired the revolver and that it had just, quote, gone off. Baldwin made this assertion public as well in multiple media interviews conducted after the shooting, none of which was a good idea, folks. Many media interviews and law enforcement interviews were conducted by Baldwin, and he displayed very inconsistent accounts of what happened during the incident when firing the gun that killed Hutchins. Now, in terms of this inconsistency, folks, some of it may be deliberate. As he realizes he's in more trouble, he's trying to change the narrative. Some of it may be inadvertent. If someone were holding a gun in their hand and it magically went off by itself with no manipulation by them, they might also say, I was holding the gun that fired. Doesn't mean they fired it. But it also doesn't matter. Because again, for Hutchins to be shot and killed by Baldwin, he had to violate a bunch of safety rules, right? Not checking the gun wasn't loaded, not pointing the muzzle at her, and not depressing the trigger. Hey, thanks, Bunny. $20 super chat from Bunny. No question, just a gift, I suppose, for me being in the office on a Sunday morning. Thank you very much. Photo and video evidence from inside the church on the day of the shooting shows some of the rehearsal up to and including moments before the shooting. I've shared this video with you separately. The photos and videos depict the above described actions of Baldwin prior to the shooting, practicing drawing and pointing the weapon. The photos and videos clearly show Baldwin multiple times with his finger inside of the trigger guard and on the trigger while manipulating the hammer and while drawing, pointing, and holstering the revolver. So he's both cocking the gun and depressing the trigger while pointing the gun at Halyna Hutchins, which could theoretically be done with complete safety if only he'd first checked to make sure the gun was unloaded. Continuing, the revolver involved in the shooting was seized by detectives as evidence. It was later submitted to the FBI crime lab for examination and analysis. As part of that examination analysis, the FBI conducted a malfunction check of the revolver. This involved trying to get the weapon to fire without the trigger being depressed, i.e. by striking the hammer at various multiple angles against the solid object and striking the hammer of the revolver with an actual hammer mallet. This is a very common test, folks. They do this to prevent an accused from being able to argue specifically that the gun just went off by itself through some kind of malfunction. Here, continuing, the revolver did not malfunction, i.e. it fired when it should not have or accidentally. This analysis clearly showed that the weapon cannot accidentally fire. For the weapon to fire, the trigger had to have been depressed/pressed. The analysis additionally including testing of and documentation of the sear engagement points of the hammer as it moved from the position of at rest all the way down against the frame in the lowest position through each engagement of the single action hammer mechanism. The firearm possessed 1/4 and 1/2 cock position safeties and were found to function as designed. That is, keeping the hammer from striking a cartridge primer without pulling the trigger. Additionally, at the 1/2 cock, the cylinder was partially rotated, making it impossible for the hammer and attached firing pin to strike a primer. So for folks who don't know how the single action gun works, it's not like a modern double action revolver where the entire cylinder swings out of the frame so you can load rounds into the fully exposed cylinder. Here the cylinder is kind of fixed in position. It can rotate on a pin, of course. That's why it's a revolver. But to load rounds into it or eject rounds from it, there's a little, like a swinging door. They call it a loading gate near the rear of the cylinder on the frame of the gun. You pop open that gate and it exposes the rear of each cylinder in the revolver individually. As it turns, each cylinder is individually exposed. There's an ejection rod you manually manipulate to eject brass that's already in there, and then you can insert a new bullet into that chamber, rotate the revolver a little bit, and it exposes another chamber. Do the same thing, one at a time. Normally, of course, you want the cylinder locked in position when the gun's firing so that the bullet is aligned, the bullet and the cylinders are properly aligned with the barrel, but it also needs to be able to spin freely at other times. For this loading function, you typically partially cock the hammer, and that unlocks the revolver so you can rotate it for each of the cylinders. As a safety provision, when you partially cock the hammer, you don't want the hammer simply to be able to fall forward if it slips out from under your thumb and discharge the gun. So there are safety cocking positions built into the gun. You pull it back a quarter of the way and it clicks. In fact, you can very distinctly hear the clicks as you go through this process. It clicks, and now it can't fall forward by itself. Half cock, it clicks again, cannot fall forward by itself. Even if you pull the trigger, it would not be expected to fall forward. It's not until you fully cock the hammer that now you can depress the trigger and fire the gun. And all these safety mechanisms were in place and working in this particular firearm. The FBI additionally analyzed various types and kinds of ammunition seized from the scene, including the prop truck. This included dummy rounds, blank rounds, and suspected live ammunition. A total of 5 suspected live rounds, 1 spent casing of a live round that was discharged, causing the shooting, were seized by the investigators. Evidence and statements indicate that aside from Hannah Gutierrez-Reed, the armorer, aside from what Hannah Gutierrez-Reed, the armorer, may have brought to the set with her, all weapons and ammunition, blank and dummy, for the production were obtained from a supply company in Albuquerque, PDQ Arms and Props, LLC. Detectives investigated these facts, including service of a search warrant at the place of business of PDQ Arms and Prop in Albuquerque, who was the supplier of the dummies and blanks to Rust. Several suspected live rounds of .45 long Colt caliber cartridges were seized as a result, some supplied by the company owner to investigators and some found at the place of business. These rounds were submitted to the FBI for comparison with the suspected live rounds found at the shooting scene. The explosives chemistry examination of the rounds showed that the smokeless powder in the live rounds found at the scene did not, and this is bolded, did not match the live rounds seized from the Props arms supplier in question. This means the live rounds on Rust did not match the rounds explosive chemistry taken from the PDQ Arms and Prop. So this is obviously good news. Presumably they actually took the powder from these various rounds, put them on something like a mass spectrometry machine, which chemically, how can I put it, provides like a chemical fingerprint, and the fingerprints didn't match. The live rounds on set did not match the live rounds from PDQ. That doesn't mean that the live rounds on set didn't come from PDQ. They may have been the last of a set, right? PDQ said, here, take this partial box. And that was all the rounds with that particular gunpowder chemical composition. But it certainly would have been worse for PDQ if they had matched up, because then it would have been a reasonable inference that the rounds on set came from PDQ. So that certainly helps in terms of PDQ's potential liability here. By the way, it's quite possible that there are a number of people who have criminal liability, certainly civil liability, for this shooting beyond Alec Baldwin. Halyna Gutierrez-Reed, the armorer, she's just like Alec Baldwin. She's also been charged. Well, the DA has released a probable cause statement for involuntary manslaughter for her as well. One of the assistant director who handed the gun to Baldwin supposedly identified it to him as a cold gun. He took a plea deal for, I believe it was negligent handling of a firearm. No time served, 6 months suspended sentence, 6 months parole. So there are clearly other people here facing or having actually suffered criminal liability for this event. But the fact that other people also did things wrong doesn't relieve Alec Baldwin of his own misconduct, to be very clear about that. The FBI lab determined that the 5 suspected live rounds recovered at the scene of the shooting were indeed live rounds, each possessing an unfired primer, powder, and bullet as part of the cartridge. So, of course, those are the 4 components of a round, right? The brass case, the lead bullet, the gunpowder, and then the primer that ignites the gunpowder. These live rounds were found by detectives and crime scene technicians while processing the scene. The 5 unfired rounds were found in the following locations. 1 from Santa Fe Sheriff Office Lieutenant Benavidez's patrol vehicle. Apparently, he had seized that round from Reed upon his arrival. 2 from the top of the armorer's cart, including the one spent live round casing. 1 from a bandolier on the cart. 1 live round from Baldwin's holster located inside the church. And 1 from an ammunition box located on the armorer's cart. This is obviously as catastrophic, right, folks? I mean, the cart is where they keep the guns that are not supposed to have live ammo. They're supposed to be props used on set. You definitely don't want live ammo anywhere near them in that context. And yet here there were a handful of live rounds just rolling around on the cart. Evidence, and by the way, that part would certainly be the most direct liability would be that of Hannah Gutierrez-Reed, the armorer. Baldwin might have some kind of vicarious liability as a director or producer of this movie. He was involved in the hiring of Reed, the armorer. But in terms of direct personal liability, those rounds rolling around on the cart's obviously the direct responsibility of Gutierrez-Reed, the armorer. Evidence further shows that Baldwin, as an actor who has extensive experience in the film industry involving firearms, failed to demand at least 2 safety checks between the armorer and himself, and witnessing the handling of firearms by a first assistant director. This would be the guy that took the plea deal on negligent handling of a dangerous instrument, I believe is how New Mexico words it. Standard protocol is the armorer is to show the actor the firearm, pull the bullets out in front of the actor, and demonstrate there are no live rounds, but dummies, meaning only dummies, in the firearm. This, folks, is how you ensure there's no live rounds in the gun. Now, I would argue that Baldwin doesn't necessarily need the armorer to do this. Any person who's responsible in handling firearms ought to know how to verify the gun's not loaded with live rounds. But in fairness, there's an armorer on set. In any case, the final responsibility is in the hands of the person handling the gun. Either he needs to check himself or he needs to observe in real time the armorer doing it, being shown directly that the gun he's about to take into his own hands and handle on set has demonstrably been checked to ensure it doesn't contain live rounds. Continuing, Baldwin knows this is standard safety protocol as he has mentioned it in media interviews and in law enforcement interviews. So obviously, like I said, none of those interviews helped Baldwin. This is part of the reason why, because it establishes his knowledge of the safety rules around this inherently dangerous instrument, the firearm. Hannah Gutierrez-Reed, here after Reed. So that before, the first time they mentioned Reed, I kind of blanked on the name because they didn't do this. Normally they would do this the first time they mentioned someone in this kind of document. I presume it was an editing thing where they were moving paragraphs around and they just didn't catch it. Hannah Gutierrez-Reed, here after Reed, did not do this protocol in front of Baldwin. Baldwin did not object to this action. It's not an action. It's a failure of action, absence of action. Reed discusses in her interviews with OSHA and law enforcement this should have occurred. Reed also acknowledges in her interviews she should have been in the church with the firearm at all times. Instead, she left the church while Baldwin was in possession of a firearm in close proximity to the cast and crew. Baldwin further acknowledges that it is standard protocol for armorers to stay with the firearm at all times in the media in interviews. So those last few lines really go to Gutierrez-Reed's criminal liability here rather than Baldwin's. Finally, Baldwin directly pointed a firearm at Hutchins and Souza. Whether guided by her directions or not, Baldwin knew the first rule of gun safety is never point a gun at someone you don't intend on shooting. In addition, always assume a gun is loaded. Had Baldwin performed the required safety checks with the armorer, Reed, or even independently of her, this tragedy would not have occurred. In addition, if Baldwin had not pointed the gun at Hutchins and Souza, this tragedy would not have occurred. So 3 simultaneous failures, as we talked about earlier, right, folks? First of all, he did not ensure there were no live rounds in the gun. Had he done that, no tragedy. Having failed to do that, he pointed the gun directly at Hutchins and Souza. Had he not done that, no tragedy. And then he manipulated the firearm to discharge the weapon. Had he not done that, no tragedy. 3 rule violations simultaneously to result in the death of Hutchins and the serious bodily injury to Souza. This reckless deviation from known standards and practice and protocol directly caused the fatal shooting by not receiving the required training on firearms, deviating from the required duties of checking the firearm with the armorer, letting the armorer leave the church against protocol, deviating from the practice of only accepting the firearm from the armorer, not dealing with safety complaints on the set. Again, now they're talking about stuff that they haven't talked about previously as if they're summarizing. I suspect that's because they moved paragraphs around and didn't clean up the language. Not dealing with safety complaints on the set, not making sure the protocol of safety meetings was occurring, putting his finger on the trigger of a real gun, not using a replica firearm for the unscheduled rehearsal, pointing the gun at Hutchins and Souza, and the overall handling of the firearm in a negligent manner. Baldwin acted with willful disregard of the safety of others. Willful disregard, that's knowing disregard, and in a manner which endangered other people, specifically Hutchins and Souza and everybody else behind the camera. Baldwin clearly should have known of the danger of his actions, which led to the death of Hutchins. In fact, when you're handling the gun, it's not a question of should have known. It's presumed that you knew the gun was dangerous, unless you adhere to the safety procedures. Now, this question of putting his finger on the trigger of a real gun, that actually could have been a huge issue in this case, relieving Baldwin of all liability if he had, from the beginning, from the first moment that gun made a loud noise, said, "Holy crap, I had no idea this was a real gun. I thought this was an inert prop, incapable of firing a bullet." Well, if he genuinely believed that, then pointing the gun at someone and manipulating the gun as you would to fire a gun and not checking it for live rounds would not be safety violations. If he had a genuine, reasonable belief that he was not handling a real gun. Because if you're not handling a real gun, you're not handling an inherently dangerous instrument. So if he had said that from the beginning, that would have relieved him of all liability, civil and criminal. Because it would have been the scenario I described as a genuine accident, where you're carrying an unmarked box. You have no reason to believe it's a possible risk to anybody. The trouble, of course, is to make that claim credibly, he would have had to make it from the start. And he never did. He always acknowledged that he knew he was in possession of a real gun. All right, so next section is Baldwin as producer. This is kind of the corporate liability aspects of this, which I've not covered before. I don't think it's lacking in merit. It's just my expertise is use of force, not corporate liability. So I simply didn't, and it's not necessary. It's not a necessary component of the involuntary manslaughter. What we've read so far is more than enough for involuntary manslaughter. But let me look through and see if we have, before I proceed, questions that need to, let me refresh that page. Douglas, law self-defense member. Douglas asks, are there any reasonable legal arguments for why Baldwin would not be charged for the shooting of Joel Souza? No legal arguments. There may be pragmatic arguments by the prosecutor. I don't know. I mean, I would have charged him with reckless endangerment for Souza, who was actually struck, and for everyone behind the camera who was threatened. But it's possible the prosecutor is just making a strategic decision that she wants to keep the case as clean and narrowly defined as possible. Also, she may want to cut a deal. She may be amenable to some kind of plea deal with Baldwin where he doesn't have to do prison time, for example. And that's harder to justify if you're pleading away as the prosecutor, 8 different felony charges as opposed to just one. Law self-defense member Scott asks, how does any other person's responsibility absolve Alec from any responsibility in the shootings? It does not. What other people did bad does nothing to relieve Alec of any of his own personal responsibility. I'll check out the super chats. More than one person can be responsible for this bad outcome, even criminally responsible. And if so, they ought to be held accountable. All right, a couple super chats. I mentioned Evil Bunny. Thank you very much. $20 super chat. That's always appreciated. No question, just a gift. Mr. Tom 2385, £5 Thank you so much. Will they be tried together or separately? They'll be tried separately. It's not unusual to see defendants tried together, but usually that's when the facts underlying their arguable criminal liability are essentially the same set of facts. For example, in this Tyree Nichols arrest, death, all those officers, the 5 officers that have been charged, involved in the use of force in his arrest, they're all basically involved in the same event. If there were an officer who were being charged that was involved only at the first stop, but not at the arrest that caused the injuries to Tyree Nichols, I would expect him to be tried separately. So where the facts are very similar, the jury will be hearing an essentially identical set of facts. It's not uncommon for the defendants to be tried together. But here, the duties and the misconduct by Hannah Gutierrez-Reed on the one hand and Alec Baldwin on the other are sufficiently distinct that I would not expect them to be tried together. And one reason you generally, I mean, as a defense attorney, I never want my clients tried with someone else, because the bad stuff that's being said about the other defendant tends to taint my client as well, right? So I want my client to have the cleanest possible defense, and that means a single defendant trial. Okay, let's talk now about Alec Baldwin as producer. Baldwin as producer. Industry standards, best practices, common practices, historical practices, policies and or procedures, and union-guided policies and or procedures require and or mandate certain members of a filming crew have, assume, or are assigned certain obligations and responsibilities. Makes sense? Industry experts and or armorers were consulted for information and evidence in this industry. Now, that might be one reason that it took 13 months, 14 months for the prosecutor to arrive at the same charging conclusion that I arrived on within days of the shooting. That's fine. Still seems a little bit long to me, but whatever. Baldwin asserted and is clearly shown to be a producer on this particular film. Based on his position, Baldwin, through the acts and or omissions, contributed to or failed to mitigate or address multiple significant safety violations, issues, and or concerns that resulted in multiple noted instances of recklessness leading up to, contributing to, and causing the shooting. So, folks, what's really being argued here is an entirely independent, parallel legal basis for involuntary manslaughter on the part of Baldwin. Imagine there was not one Alec Baldwin. There were 2. They were twins. Alec Baldwin 1 and Alec Baldwin 2. And Alec Baldwin 1 is in this producer role, but never touched the gun that shot Halyna Hutchins. And Alec Baldwin 2 was not a producer of this. He was just an actor, but he was the one handling the gun. Each of them separately. Now we have the fire department coming through. I'm 2 blocks from the fire department, folks. I know. For someone who does live streaming almost every day, how could I possibly pick an office location like this one? I'd have to be crazy. Da, 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 da. Now I think I hear someone's dog howling back at the fire trucks. All right, so Alec Baldwin 1 and Alec Baldwin 2 could each independently be guilty of the crime of involuntary manslaughter. Alec Baldwin 1 for failing his obligations as a producer, failing to act in ways he should have, and committing omissions of acts that he should not have committed that created an environment of recklessness. In other words, he should have known by his misconduct as a producer that his misconduct was creating a environment of recklessness, and therefore he knew the environment he was allowing to exist, despite many rules that said don't do it this way because someone could die. He was knowingly allowing a reckless environment to exist that created an unjustified risk of death or serious bodily injury to others. The second Alec Baldwin 2, is the guy who was handling the gun. So he's responsible for involuntary manslaughter simply on the mishandling of the gun alone. That's enough. But it's also possible that even if Alec Baldwin had not been the person handling the gun, he could still be found liable for criminal involuntary manslaughter based on his failure to meet his responsibilities as a producer on the show. That's what the courts are on the DA is arguing here. Let's see. Since the shooting, Baldwin has asserted publicly that he is an expert in the realm of firearms and filmmaking. I think that would certainly have to be true. Investigation has revealed that Baldwin has been involved in at least 40 films or TV productions that involve firearms, with Baldwin either directly handling firing a weapon or in a scene with firearms being directly handled and or fired by someone else. Further investigation of this list revealed a multitude of instances, either from the movie itself or from the movie poster, showing Baldwin with his finger on the trigger guard. Like another train already. Oh, lordy, lordy. He loves that conductor. He loves that horn, man. He loves it. All right. Further investigation from this list of movies revealed a multitude of instances, either from the movie itself or from the movie poster, showing Baldwin with his finger on the trigger guard and on the trigger in instances where, according to industry standards and common firearm safety standards, it should not have been. Experts, industry standards, and basic firearm safety protocols and training consider this reckless behavior requiring immediate remediation. All right. I'm no fan of Alec Baldwin, but this paragraph is bullshit. It's bullshit. Because it's quite possible to have your finger on the trigger of a gun and have it be completely safe, as long as you're not breaking additional gun safety rules. So you personally ensured the gun was not loaded, and you didn't point the gun at something that you didn't intend to kill or destroy. Then it can be perfectly safe to have your finger in the trigger guard and on the trigger. So it's possible to do this safely. I mean, we've all seen movies where guns are held to an actor's head as if he were going to self-delete, right? The Deer Hunter, for example, famously. And I'm sure that was a real gun that was used, particularly given the era the movie was made. It can be done safely. Just make damn sure that you've checked to make sure there's no rounds in the gun. Also, a lot of these things, especially the posters, first of all, they're staged. They're staged. They're not supposed to be an exemplar of gun safety. Second of all, my understanding is that many of these movie posters are actually painted. They look like photographs, but they're actually illustrations. So I call bullshit on this particular paragraph. Certainly, if such evidence were being introduced at trial and I were defending Alec Baldwin, I would argue vigorously that it was prejudicial evidence that had little or no probative value in the case and should not be admitted. Continuing. Evidence shows Baldwin failed to appear for mandatory firearms training and firearms safety training prior to the film. Well, that's a problem. Evidence also shows Baldwin requested and was afforded a training session on set, and that through statements, the training was estimated to be 30 minutes in length due to the distraction of him talking to his family on a cell phone during the training. I'm sure many of you in the comments have taken safety training for work. Would they qualify you through that training if you were chatting on your cell phone at the same time? So basically, even the 30 minutes was worthless. The onset and limited time of training does not comport to industry standards, and evidence shows Baldwin was in a position to manage, oversee, commence, and require safety training to industry standards. So again, if we imagine two different Baldwins, Baldwin 1 and Baldwin 2, Baldwin 2 is the actual shooter. Baldwin 1's just a producer, never touches the gun. Baldwin 1, if he was aware that Baldwin 2 had done the safety training in such a perfunctory manner, Baldwin 1, the producer, would have an obligation to make him do it again the right way to avoid having a reckless environment. Continuing, Baldwin's failure to ensure minimum standards were met is considered reckless. Again, criminal liability, right? An aggravated form of negligence. Knowingly creating an unjustified risk of death or serious bodily injury to others, that's recklessness. Creates criminal liability, not merely civil. Also civil, of course. Basic firearm safety protocols and industry standards are provided during this training, which includes basic firearm safety rules and mindset, including but not limited to, here we go, we've talked about this before, not touching, pressing the trigger until the shooter is ready to fire, and, a separate rule, is sure of her target. Treating all firearms as if they are loaded. Not covering anything with the muzzle of a firearm, the shooter is not willing to destroy. The evidence clearly indicates that Baldwin recklessly ignored these rules on multiple occasions, resulting in the fatal shooting. So again, this paragraph feels to me like it's in the wrong place in this document. This paragraph feels to me that it belongs in the first section, where we're talking about the Alec Baldwin number 2 theory of liability for involuntary manslaughter, the mishandling of the gun. Again, it feels kind of sloppy production of this, that were moving paragraphs around in the editing process and never checked to make sure they actually had stuff in the right place. This portion of the probable cause statement is supposed to be addressing his kind of vicarious corporate responsibility liability for recklessness and involuntary manslaughter, not the safety rules per se. Continuing, evidence shows that the production company hired Reed as the lead armorer for the production. By the way, Reed, this is Hannah Gutierrez Reed, the armorer. Her dad, Fel Reed, is a very famous movie Hollywood armorer. Lots and lots of famous movies, been around for decades and decades. He's an old guy now. This is his daughter. She's trying to get into that industry. I think this was her second film. I may have heard she was thrown off the first film. Don't hold me to that. But anyway, she's very much a novice at this. This is a low-budget Western movie. They probably couldn't afford Fel Reed, so they're hiring his relatively young daughter instead, presumably at a much, much lower cost. And of course, she would probably take the job for nothing, just to get the experience on a resume of having worked as an armorer on a movie set. Evidence shows that the production company hired Reed as the lead armorer for the production. Evidence shows that Reed possessed no certification or certifiable training or union card for this practice, and that she admitted she was the armorer for only one film prior to this production, approximately in April of 2021, so a few months earlier. As the producer of a firearm-intense film, evidence shows that Baldwin allowed, through acts or omissions, the hiring of inexperienced and unqualified Reed for this production, failed to mitigate or establish more precautions to protect against Reed's inexperience, or failed to demand the minimum safety standards, protocols, and requirements on set. Yeah, so the argument here would be, listen, if you wanted to give this girl some experience, maybe make her the assistant armorer and hire a real armorer who's done 10 or 15 or 20 movies before as an armorer, has demonstrated he can do this safely, not someone who's done it only once. That's not someone you put in the head armorer position. The state will be arguing. Continuing, Reed was assigned by production to be an assistant prop master in addition to her armorer duties. So not only is she barely competent, if at all, in the armorer job, now they're diluting her focus on that one job by giving her a second job as well. Evidence shows that this resulted in Reed not focusing her entire attention on her primary responsibility as armorer. Evidence shows Baldwin violated industry standards and practices by allowing this reckless and generally prohibited practice, resulting in lots of reckless now, actions taking place prior to and on the day of the shooting. Evidence shows that Sarah Zachary was hired as the prop master for the production. It also shows that she was assigned to assist Reed with her armoring duties. So now Reed has an assistant, but the assistant is even less competent than Reed is. Evidence and statements show that Sarah Zachary possessed little to no experience with firearms, firearm safety, armorer duties, and responsibilities. It also shows that Sarah Zachary was allowed to load and unload ammunition in firearms, handle firearms, and act as an armorer when on set, with actors doubles taking possession of the firearms. Evidence shows this was done multiple times and without Reed being present on the set as well. Evidence shows that despite the production team's awareness of the safety issues, Baldwin did not address this reckless process procedure that is contrary to industry standards and safety protocols and commonly understood firearm safety procedures. Prior to the shooting incident, Sarah Zachary, the assistant armorer, had a negligent discharge while handling a revolver intended to be used by an actor in the filming. This weapon was not Baldwin's weapon, but had same mechanical function and appearance, a single-action revolver, and was intended for use by the quote-unquote marshals. Statements show that Sarah Zachary was holding and manipulating the weapon while walking, and she discharged a blank cartridge into the ground next to her foot. Industry standards, practices, and protocol consider negligent discharges reckless in nature that require immediate action and/or swift mediation up to and including remedial training, demotion, removal from the set, termination, etc. Evidence shows Baldwin failed to act to address this reckless situation or to direct Reed to mitigate or address the situation. So I want to come back here because this language can often be confusing. Industry standards and practices and protocol consider negligent discharges reckless in nature. I talked earlier about the difference between negligent and reckless, right? And I was providing a legal definitions of those. And I identified recklessness as being a kind of aggravated form of negligence. What might have been negligence becomes recklessness if the same conduct takes place in the context of handling an inherently dangerous instrument like a gun. It kind of automatically elevates the negligence to recklessness. It's common parlance in the gun safety community to refer to the unintended discharge of a gun as a negligent discharge. But common definitions of words and legal definitions of words are different. It should always be referred to as a reckless discharge of a gun. Okay, continuing. Also, prior to the shooting incident, another negligent discharge was committed by a stunt double as he was manipulating a lever action period rifle loaded and left unattended with the stunt performer while in a holding tent. Baldwin failed to act, the evidence shows, to address this situation, this reckless situation, or to direct Reed to mitigate or address the negligent discharge. So for folks who don't know, the situation with Western type lever action guns is slightly different, but much the same as with the single action revolver. So with a lever action gun, the trigger is single action, not double action. Double action would mean you could depress the trigger and it would cock and drop the hammer. On a lever action gun, the trigger can only drop the hammer. The hammer has to be cocked by other means. On the revolver, the single action revolver, you typically cock the hammer with your thumb. And you can do that on a lever action too. You can cock the hammer with your thumb. Or you can cock the hammer by cycling the lever forward and then back up. That lever then both cocks the hammer and loads a round into the chamber. And if there was a round already in the chamber, it would extract and eject that round from the chamber. The point is, if you're walking around with a lever action and you're playing with the hammer and you've cocked it, the amount of pressure you need on the trigger of a single action gun to drop that hammer is very modest. Easy to do unintentionally if you don't have a disciplined trigger finger, meaning you're letting it wander around the area of the trigger, and almost anything happens. You get startled and you clench your hand. Very easy to put enough pressure on that trigger to unintentionally, recklessly discharge that firearm. Through evidence and interviews, these reckless and serious safety violations were deemed negligent by the investigation, as there were no indications or evidence that the firearms in question malfunctioned at any time. Rather, there is evidence the weapons fired because of mishandling, misuse by those handling the firearms, pressing the trigger when it should not be. All right, so this paragraph I just hate, obviously, because it's conflating these legal terms, and this document's written by lawyers, of recklessness and negligent. To say these reckless and serious safety violations were deemed negligent is retarded in a legal context. They were either reckless or they were negligent. If they were negligent, there's civil liability, but no criminal liability. If they're reckless, they carried criminal liability. Properly written, the sentence should read, these serious safety violations were deemed reckless. That's it. Sloppy writing, drafting. And it's suggesting that the person who drafted it doesn't have a robust understanding of the legal doctrines they're talking about here, which unfortunately would not be uncommon in legal circles. Continuing, in his producer's position, the evidence indicates Baldwin also did not act to address the lack of daily safety meetings that are required to be conducted by the first assistant director. Evidence indicates that on or about the 13th day of filming, only 3 or 4 safety meetings were conducted by the assistant director. Practice and standards investigated indicate that a daily safety meeting should be conducted with the crew, regardless of the scenes for the day's shoot. The lack of meetings, the lack of appropriate content of said meetings resulted in a climate of recklessness as evidenced by the conduct of the cast and crew, documented through statements and evidence. In addition, no safety meeting was conducted on the day of the incident. Safety meetings were supposed to be listed on the call sheet daily, but were not. Meetings were called randomly throughout the day with no mandatory attendance required. So that's pointless. The meetings were impromptu. Hey, everybody fall in. Let's talk about gun safety. The meeting should, pursuant to standard protocols, be conducted in the morning prior to the beginning of the day, where all members of the cast and crew should be required to attend. Yeah, so if you ever shoot an organized match, a pistol match, a rifle match, before there's any shooting involved, maybe you get assigned to your squads and so forth for the day. But before you go to your various stages and begin shooting, there's typically a safety brief where everyone is gathered together to go over the safety rules, generally any specific safety rules for that particular range. And by the way, most of the people, probably 95% of the people in that group of shooters at the competition have shot many, many matches, many of them at that range. But they all show up, and they're all required to show up to hear the safety briefing before the competition goes live. On October 20th, 2021, the original camera crew resigned, citing safety concerns, commute times and distances, pay, and other issues. On October 21st, this is the day of the shooting now, 2021, a new crew was brought in to begin filming right away. Evidence indicates that during the church scene in question, the director and director of photography should have been outside of the church, viewing the scene from a large monitor covered by a tent shade screen, commonly referred to as Video Village. Statements indicate that Joel Souza, the director, and Halyna Hutchins, who they're calling the director of photography, also the cinematographer, decided to be in the church with the camera crew due to the abrupt change of the camera crew. Evidence indicates that Baldwin failed to act to address any safety or continuity concerns with the new crew, causing a reckless situation to occur on the day of the shooting. Again, another call out to recklessness, which is what's required for involuntary manslaughter here. On the day of the shooting, evidence and statements show that impromptu plans were made to rehearse and then shoot a scene inside of the church. And for this particular scene, it was to only involve Baldwin. Evidence and statements show that the first assistant director, David Halls, hereinafter Halls, was present on the set. As with Baldwin, evidence, common standards, protocol, and statements show that Hall had the additional duty of safety coordinator by virtue of his position. However, that position does not allow the handling or manipulation of firearms. Evidence and statements also show that Halls, by virtue of his position, is the first point of contact for an armorer when they bring a firearm on set and is the first person required to conduct a safety check with the armorer and weapon. Industry standards and procedures require that the armorer, in the presence of the first assistant director, here Hall, show the weapon is clear and safe. Then, if applicable, show the firearm is loaded with blanks or dummy rounds, visually and physically checking each round individually for safety by pulling each round out of the firearm and showing the first assistant director and the actor. The first assistant director then follows the cue of the armorer calling cold or hot weapon on set, then broadcasting that statement across the radio, which notifies all cast and crew. Evidence clearly shows this did not occur. Obviously, the gun discharged and shot Halyna Hutchins and Joel Souza. Evidence clearly shows this did not occur on the day of the shooting at least 2 times. Baldwin failed to address these reckless incidents and deviations from industry standards and firearm safety rules, directly contributing to the fatal shooting. Halls did not adequately check the firearm with Reed prior to handing it to Baldwin, who additionally, this is Baldwin now, who additionally did not check it with the armorer Reed. This goes back to Baldwin's personal responsibility as Alec Baldwin number 2, the guy handling the gun. Halls is further required to announce to crew when a firearm will be fired in the scene, i.e. announce fire in the hole, or other common phrase to put the crew on notice for shooting or loud noise, hearing protection, etc. I would suggest eye protection as well. The evidence and statements show that this requirement did not meet safety and industry standards, and further shows that Baldwin failed to address and or mitigate this reckless and dangerous practice. Halls, again, by virtue of his position in industry standards and practices, is prohibited and or strictly discouraged from handling any of the firearms on a set. As such, industry standards, policies, and practices call for the armorer to be on set and to stay on set anytime a firearm is on set. This practice and standard were not conducted on the day of the shooting and was allowed by Baldwin. Prior to lunch, statements and evidence show that Halls requested Baldwin's firearm be prepped and brought to the set by the armorer, Reed. Reed states that she loaded the firearm with dummy rounds prior to lunch, so she didn't perform a second safety check on her own or with Halls, and the firearm, just showing him the barrel and not removing the bullets to show the firearm was safe, and then Halls took possession of the firearm from Reed. Folks, if you check a gun in your hand to make sure it doesn't have live rounds in it, and that gun leaves your hand, I don't care how transiently, it's no longer in your immediate control. If you take repossession of that gun, the first thing you do is again check to make sure that no live rounds have found their way into that gun. Because you don't know what's been going on with that gun in the interval. You check it every time it comes into your hand. You don't tell yourself, well, I checked it this morning before lunch, so I'll just assume it's unloaded. Guns are always assumed to be loaded until affirmatively demonstrated otherwise by you. Maybe also other people, but by you holding the gun. Continuing. Reed departed the church. Halls provided Baldwin with the firearm so he could rehearse practice with the weapon. However, there are contradictory statements that Reed brought an empty gun to Halls and at some point loaded it with dummy rounds while in the church. Reed then showed Halls the firearm. Again, Reed did not do a proper safety check with Halls or Baldwin. The lack of a proper safety check here is demonstrable, right? It's incontrovertible because the gun, in fact, fired an actual round. There was a bullet in the gun. So the safety checks that involve making sure there's no live rounds in the gun clearly weren't done. Again, Reed did not do a proper safety check with Halls or Baldwin. Reed then left the church. Reed leaving the set and Halls handling the firearm are considered very reckless actions according to industry standards, expectations, and common firearm safety protocols and considerations. There is no evidence or information that Baldwin addressed or acted to mitigate these reckless acts. In addition, for a rehearsal, a rubber or replica firearm should have been used. Only when the actual scene was to be filmed should the weapon have been loaded with dummy rounds. Baldwin, Halls, and Reed all knew this was standard protocol. So, by the way, folks, I will also question this. I can imagine a cinematographer wanting the actor, while they're setting up the shot, to be holding the actual gun that will be in the shot. Some guns are shiny, some guns are flat, some guns, how they look in the light could well be different between a plastic rubber version or a replica version. But again, it can be safe. It is safe to handle a real gun in rehearsal if only you follow the safety rules, or at least don't break more than one simultaneously. Continuing, further evidence and statements show that when the crew took a break for lunch, firearms, including Baldwin's, were secured in the prop truck safe. Outside of the church was a cart used by the armorer and prop master, contrary to standard protocol, that contained leather gear rigs like holsters, belts, and ammunition. Evidence clearly indicates this cart and associated items was not secured during the break and was not in visual range of Reed or Sarah Zachary for safety and security. The unsecured cart with equipment, ammunition, and firearms is considered very reckless by industry standards and by common firearm safety standards and protocol. Evidence indicates that Baldwin failed to act to address and or mitigate these serious and reckless safety violations. Upon returning from lunch, evidence and statements show that Reed retrieves Baldwin's preferred revolver, but Reed does not perform another safety check. Additionally, Reed again is asked and complies with Halls by handing him the firearm once inside the church. There are also contradictory statements that Reed brought in the firearm empty, showed it to Halls, and ultimately later loaded it with dummy rounds. Regardless, the evidence is consistent that Reed failed to show Halls each dummy round and pull them out for safety, nor did Halls request it. Reed did not show Baldwin the loaded firearm either, nor did he request to see the rounds, which is standard protocol. Again, it's incontrovertible. They did not ensure the gun did not contain live ammo because the gun contained live ammo, the round that killed Halyna Hutchins and wounded Joel Souza. This after-lunch sequence of events is documented to have had no less than 4 extremely reckless violations of industry standard safety protocol, best practices, and common firearm safety protocols in a very short, compressed period of time. On the day of the shooting alone, evidence shows that no less than a dozen acts or omissions of recklessness occurred in the short time prior to lunch and the time of the shooting, and this does not include the reckless handling of the firearm by Baldwin. Baldwin, by act or omission or failure to act in his position as a producer, directly contributed and or failed to mitigate numerous reckless and dangerous actions during a very short time period. Finally, industry standards and protocols and common safety firearm procedures on movie sets require the armorer, after conducting a safety check with the first assistant director, to conduct a second safety check with the actor to be handling the firearm. So Baldwin cannot simply, and again, this really applies to his personal handling of the gun, the Alec Baldwin number 2 scenario. He can't say, well, I relied on other people to check the gun for me. I'm just an actor. It's their job to make sure there's no bullets in the gun. Nope. Industry standards, protocols, and common safety firearm safety procedures on movie sets require the armorer to conduct a safety check with the actor to be handling the firearm. This reckless violation of standards and firearm safety occurred 2 times leading up to the shooting, and Baldwin failed to act to mitigate or correct the reckless safety violations, neither in his capacity as actor, the person handling the gun, nor producer, the person with corporate liability for ensuring a non-reckless movie set. Continuing, this reckless deviation from known standards and practice and protocol directly caused the fatal shooting. Baldwin acted with reckless disregard and or more than mere negligence in this incident. So they finally got it right. It's more than mere negligence. It's not that he should have known an unjustified danger of death or serious bodily injury. It's either he did know or it's presumed that he knew, either because of the inherently dangerous nature of firearms or because of this overarching responsibility he has for safety as a producer of the movie who's on set. More than mere negligence in this incident, Baldwin acted with a willful disregard. That's another way of saying reckless. A willful disregard of the safety of others and in a manner that endangered other people, and he clearly should have known the danger of his actions, which led to the death of Hutchins. Furthermore, Baldwin handled the weapon in a negligent manner. Again, folks, when you're doing something that would otherwise be negligent, but it involves an inherently dangerous instrument like a gun, it's automatically bumped up to recklessness. Evidence exists to clearly show that on October 21st, 2021, Halyna Hutchins was killed when Baldwin fired a firearm that he pointed at her. The evidence and statements documented in this affidavit confirm many instances of extremely reckless acts or reckless failures to act by Baldwin in a 10-day period. This would be Alec Baldwin number 1, the producer. The previous sentence would be Alec Baldwin number 2, the actor. Evidence clearly shows that none of the incidents or issues were addressed by Baldwin in his position as actor or producer to mitigate future occurrences of recklessness, correct reckless behavior, or correct training deficiencies. Baldwin's deviation from known standards, practice, and protocol directly caused the fatal death of Hutchins by not receiving the required training on firearms, not checking the firearm with the armorer, letting the armorer leave the firearm in the church without being present, deviating from the practice of only accepting the firearm from the armorer, not dealing with the safety complaints on set, and or making sure safety meetings were being held, putting his finger on the trigger of a real firearm when a replica or rubber gun should have been used, pointing the firearm at Hutchins and Souza, and the overall handling of the firearm in a negligent manner. Again, it's a gun, so it's reckless manner. Baldwin acted with a willful disregard for the safety of others, that's recklessness, and in a manner which endangered other people, specifically Hutchins and Souza, also other people. There were more people behind the camera. Those were just the ones killed or injured. Baldwin clearly should have known the danger of his actions, which led to the death of Hutchins. Probable cause exists that Baldwin committed involuntary manslaughter contrary to and defined in New Mexico statutes annotated Section 30-2-3 manslaughter in the commission of a lawful act, which might produce death in an unlawful manner. That's one way to commit involuntary manslaughter under New Mexico law, or without due caution and circumspection, or during the unlawful act not amounting to a felony, to wit, negligent use of a deadly weapon. So these are two alternative ways of getting to involuntary manslaughter under New Mexico law. Acting in a lawful way that might kill someone unjustified without due caution and circumspection, so not following the safety rules, or acting in an unlawful way that's not a felony that results in death. If it were a felony that results in death, it would be felony murder. So this is a misdemeanor that results in death. Also qualifies as involuntary manslaughter. It's a second path to involuntary manslaughter. And here the underlying misdemeanor would be negligent use of a deadly weapon. There's more subtleties in those two paths to involuntary manslaughter, but I've addressed them in other Baldwin content. And again, you can find all my aggregated Alec Baldwin shooting of Halyna Hutchins legal analysis and commentary aggregated at lawofselfdefense.com/Baldwin. And this is a sworn document, sworn under penalty of perjury by Robert Schilling, Special Investigator, 1st Judicial District Attorney's Office, so an investigator for the Office of the DA, who will be presumably trying this case, or allowing the special prosecutor to try the case. I'm not sure how they're planning to arrange all of that. And that's it, folks. That is. So what happens now? So they file this with the court. The court will hear argument on it. Alec Baldwin's defense counsel will have an opportunity to, I'm sure he'll file his own responsive motion saying there's not probable cause. He'll certainly argue that in court that there's not probable cause. And he'll lose because the standard for probable cause in these hearings is basically more than zero evidence. And there's a lot more. I mean, here there really is probable cause. A lot of times I see cases where there's not what I would call probable cause. There's a little bit of evidence, but not enough to meet the threshold of probable cause, and the courts allow it anyway. Here, that's not really an issue because there's a lot. Again, this is not a complicated case. It's not a close call on whether or not this is involuntary manslaughter. It's simply involuntary manslaughter by apparently, arguably, multiple legal theories to get to involuntary manslaughter. All right, let me pull up my little promo here for our upcoming Law Self-Defense Advanced class. This is the only Law Self-Defense Advanced class scheduled for all of 2023. It's our full day self-defense law class taught live by me, streamed to you over Zoom. Learn how to be hard to convict, to be an unattractive target for prosecution if you're ever compelled to defend yourself, your family, your property against criminal predation. Learn this stuff now, folks, because it's too late to learn it after you've used force. What you think you know about self-defense law is almost certainly wrong. In one day, you can fix all of that. And again, as I say, it's live, plenty of opportunity for Q&A. It's applicable in all 50 states. And if you sign up for this class in this month of February, you get 25% off your registration. lawofselfdefense.com/advanced is where you can learn more about this course and register. It's 6-7 hours long. It varies in length. It's at least 6. And then from there, it's typically an hour or 2 of Q&A. So the total duration, just think of it as a full day class and you'll be fine. All day Saturday, April 15th. And again, that's at lawofselfdefense.com/advanced. And I'll leave that up as I go through questions. So let me take a look at the Law of Self-Defense member chat. Law of Self-Defense member Scott asks, even if it were a realistic looking fake or inert gun, I think show me it's fake would be required. Well, you'd have an issue there, right? Because if it's being presented to you as an inert gun that cannot fire, and you're relying on that representation, you better have the training to be able to differentiate between a genuinely inert gun, inert prop, and a real gun being used as a prop, but capable of firing actual rounds. If you're incompetent to understand that distinction, make that distinction, you're incompetent to rely on a representation that this is an inert gun. I can't tell if this is inert or real. And by relying on that, you're assuming the risk of killing someone with a real gun because you can't tell the difference. So certainly they should present to you that this is an inert gun. You also better have the competence. It's going to be presumed that you're capable of determining it's not a real gun capable of firing real rounds, which isn't that hard, really, right? I mean, most people take an NRA pistol course, safety course in less than a day. So, right. So, I mean, that would have been a hard sell for Baldwin, that argument that he thought it was an inert gun. I don't know. It's the kind of thing where if he had kept his mouth shut and lawyered up quick, his defense lawyer might have said to him, listen, is there any possibility this could have been, you thought it was an inert gun? Because that would make your legal defense a lot easier if that were true. I'm not telling you to lie, Alec. I'm not telling you to lie. I'm an officer of the court. I'm just observing that should it be the case that you didn't even know you had a real gun in your hand, that would really make my job easier. But it's too late to do that after the fact, especially after all his interviews. All right, let me take a look now at let me refresh the super chats. Whoops. YouTube, I swear, all your money and you still can't do this right. Okay, we have a few. So again, if you want to ask questions on YouTube, it needs to be a $5 minimum super chat. Law Self-Defense members can ask all the questions they want in the member chat for free. Just the cost of being a member, which is less than $10 a month, folks. 30 cents a day. 30 cents a day. And today, for your 30 cents, you could ask me 100 questions in the member chat and I would answer all of them. Or you can pay $5 a question on YouTube. It's up to you. Either way, I appreciate the contribution and the support. But the prudent person would probably become a member, save themselves a lot of money if they like to ask questions. And you can become a Law Self-Defense member right now at lawselfdefense.com/join. Trippin Stiglitz on YouTube, $10 super chat. Thank you so much. Says, Andrew, just thanks for all your breakdowns and analysis. A bit overdue for the amount the wife and I have consumed over the last year. Keep it going. Much love. Thank you very much. I really appreciate that. Best to your wife. Evil Buddy, another $20. Thank you so much. Says, hey, Mr. Branca, is it defensive property if I kill the woodpeckers who seem to think my house is an all-you-can-eat woodpecker buffet? Joking, but I have to chase them off the house 5 to 6 times a day lately. Yeah, so there's a lot of rules about shooting animals, game, and so forth. It's not really a self-defense analysis, but you can get a lot of trouble if you shoot the wrong animal, for sure. And if you discharge a gun in a community where other people live, very common to see reckless endangerment charges with a firearm, which can easily be a felony charge all by itself. So do caution. I understand it was just a joke, Evil Bunny, but to those roughly 30% of the population has no sense of humor. So for anybody in the comments or watching this who falls into that unfortunate group, I understand it was a joke. Insanity Pepper, $10 super chat. Thank you very much. Says, why was Alec never arrested and required to post bail? Is the justice system allowed to flagrantly treat rich celebrities differently than, say, an unemployed plumber who commits the same offense? Whether someone's all right. So in theory, you're arrested to secure your body for like processing, for identification, right? That's one reason. We got to make sure who you are, where you live, and where we can find you. That's one reason to arrest somebody. Another reason, of course, is if they're an ongoing danger to the community, right? So probably Alec Baldwin would not be an ongoing danger to the community. They know who he is. They know where to find him. So the need to arrest him is rather limited. Even once you're arrested, the continuing concern is that we want to make sure you're going to show up to your trial, to hearings, and whenever the court wants you to show up. So we can either keep you in the jail, or we can release you on some kind of security, like bail, property security, cash bail, whatever the case might be. And if you don't show up when you're supposed to, the court seizes that cash or property. You lose it. They get to keep it, and then they may well send people out to go find you. Again, that's unlikely to be an issue with Baldwin. He's famous. He's not going to disappear off the face of the earth. We know where to find him. So there are rational reasons for not doing the arrest here and keeping him in jail. Do those reasons also apply to a lot of other suspects who would also be virtually certain to show up? You know who they are. They're not habitual criminals. They're not likely to drop off the radar screen, but they're jailed anyway. Yeah, it does. So partly it's just a judgment call on what they want to do. Is the system fair? Folks, nothing on God's great earth is fair. There's no fair. Fair's got nothing to do with any of this. If you expect fairness in life, you're going to be sorely disappointed. $20 super chat from And She Was. That's a good song. And She Was, $20. Thank you very much. There's no comment. There's just a little, what do you call those little cartoon things? Emoji, I guess. But honestly, I can't tell what it is. Sorry. I just can't. Maybe a green money bag? In any case, many thanks for the support. Mexican Iron Man, $10 super chat. Thank you so much. Says, thank you for another great analysis. I took your advanced class last year, and it was amazing. A++. You hear that, folks? A graduate of a prior law self-defense advanced class thinks it was amazing. A++. You, too, will share that opinion if you join us on Saturday, April 15th, 2023, for the only advanced class so far scheduled for this year. And if you sign up for that class this month, the month of February, you get 25% off your registration at lawofselfdefense.com/advanced. Let's see, another super chat just came in, I noticed. So let me refresh quickly. Snowboard Dan, $10. So this is a Murdaugh question, but he paid $10. So I'll touch upon it briefly. Just watched a Murdaugh HBO documentary talk about a crazy family of corruption. However, I don't think the state has enough evidence for murder. Yeah. So folks, I have to look at the rest of my day. If I have time, I'm going to do a second live show today on the Murdaugh case, where I will play the opening statement of the state and the defense again, so we can refresh our recollection on what they promised us at the start of this trial. Because what I'm hearing from the state so far, and we're still going through the state's case, the state has not rested yet. So maybe there's more. But if there's any big news, big testimony coming, they didn't mention it in the state's opening. But what I'm hearing so far from the state is a case that's entirely circumstantial and with no motive for him to kill his wife and son. And there exists plausible alternative hypothesis for these killings that have nothing to do with this defendant. And in that kind of case, I don't see how you rationally arrive at guilt beyond a reasonable doubt on the charge of murder for the wife and son. Now, it looks pretty clear this guy's a thorough scumbag, stole lots of money from lots of people, many of them poor people, and he'll almost certainly go to jail for the rest of his life just for the financial crimes, if they're proven beyond a reasonable doubt, which seems likely. But that's not what he's on trial for here this week. He's on trial for murder. And he ought not be convicted of murder because he committed financial crimes. He ought to be convicted of financial crimes for the financial crimes. And he ought to be convicted of murder only if murder is proven beyond a reasonable doubt on the facts and law. And so far, I don't see the state coming close to that. Doesn't mean he won't be convicted, of course. The jury might, juries can convict for any reason, really. But on the legal merits so far, I don't see the state as having presented anything like a compelling case for guilt beyond a reasonable doubt of murder in the deaths of his wife and son. Let's go, Brandon. $5 super chat says, I rewatched the defense opening. They are delivering. This is the Murdaugh stream. Well, I'm talking about the Murdaugh trial. This is really the Alec Baldwin stream. But I'm going to try to come back this afternoon and do a second live show where we go over those openings again. And then at 4 p.m. my time, so 6 p.m. Eastern time US, I'm going to be on with Legal Mindset, Andrew Esquire, and maybe also Legal Vices. Maybe Jeff will be on too. I'm not sure about that. But if you check out Andrew Esquire's YouTube channel, he's asked me to come on a show to do kind of a recap of murder. He and Jeff have been covering the Murdaugh trial too in real time. But during the week, I'm on with Nick on Nick's channel, Ricardo Law, and it's hard for me to jump around because people don't need to know where to find me. But I was grateful to be invited by Andrew English to come on his YouTube channel to do kind of a recap over the weekend. Oh, someone in the comments says Jeff will be there as well. Great. That'll be great. So I imagine we'll each have different perspectives on the case. Those are two excellent attorneys in their own right. So that should be a lot of fun at 6 p.m. Eastern time. I don't have a link, but if you Google Legal Mindset, not Google it, go to YouTube and search for Legal Mindset. You ought to be a subscriber already, folks, honestly. He is the professor for our American law classes course on property law, American property. You can learn more about that at AmericanLawCourses.com. In any case, if you don't see me later this afternoon here, although I will try to come back here, I'll look forward to seeing all of you at 6 p.m. Eastern time over at Legal Mindset's channel. All right, folks, I think that's all I have for the moment. It's been almost 2 hours. I can't believe it. We've had a couple trains. We've had a couple fires. So very, very exciting show. As always, you don't get this kind of excitement on just any law YouTube channel, folks. You have to come to Law Self-Defense for that. So please hit the subscribe button, hit the like button on this video if you liked it. Do whatever the equivalent of that is on Rumble. And to all of you, I say thank you for your support, as always, and I'll see you all again soon. Take care.